I'm very glad to have the opportunity to finally speak to this bill at report stage, although, as I just said in my previous question, I'm really sad to have to do this under time allocation and to know that many of my colleagues will not get the chance to bring the voices from their constituency to this chamber on the bill. I was prevented from speaking at second reading by the time allocation imposed by the government, but something even more peculiar happened when they did that. The abrupt change of this House schedule on May 4th with time allocation forced the second reading vote forward by 5 days. And for those of us who have responsibilities both here and in our ridings, it meant on that Wednesday morning, I was already flying west before the time allocation motion was introduced. So it meant that I could not be here to cast my vote at second reading because I was already flying in the wrong direction. So I lost my chance to go on record of voting against C-14 in principle, which I intended to do. Not just because of my own experience and beliefs, but also because I believe it contradicts the Supreme Court's Carter decision, but most importantly because the bill contradicts the opinion of virtually every person and every family in my riding that's contacted me about this issue. I've been involved in discussions about end-of-life issues with several individuals who are facing severe, debilitating, and painful illnesses. I've talked to them directly, I've met with them, and heard their concerns. Which reminds me actually to mention an important issue that's not in the bill, and that's the issue of palliative care, and the need for us as a society to do a much better job with end-of-life care. I do, though, want to praise those who are actively already working in end-of-life care. It's not a criticism of their efforts that they make each and every day to provide better care for those who are facing end of life, but they're forced to do so too often with too few resources and in substandard situations. I've been involved in public discussions locally on this issue, stretching back to a public forum on March 21st, 2015. This was jointly sponsored by a group called Victoria Choices in Dying and Dying with Dignity. And there we heard from a panel of speakers, which I was privileged to be on, but we also heard from the public, and we heard from speaker after speaker at that forum saying that they wanted the right to control end-of-life issues. They wanted the right to make decisions for themselves, and they wanted the right for their family members not to have to suffer intolerable pain for great lengths of time, but to be able to make the choice for assisted dying. So, I believe, as I said, not just speaking on the basis of my own conscience, but representing the beliefs and needs of my community, that I should oppose Bill C-14. Not just for what's in the bill, or not just for what's not in the bill, like palliative care, which only gets a mention in the preamble, and for which the government has incidentally provided no new resources, and there's no reason to wait for legislation to do that. But I'm going to oppose the bill for what's actually in the bill. I believe this bill is too restrictive and respects neither the letter nor the spirit of the Carter decision. I think we're in this unfortunate position because the government failed to listen to the key recommendations of our own special joint committee of the House and Senate. This committee made very wise recommendations with regard to the bill, yet only a few of them were incorporated into the bill at the committee stage. So in the interest of time, I'm going to focus on what I believe are the three key faults in Bill C-14. The first and most important to me is the absence of a provision for advance directives. And I want to talk, if I'm able to do so, about a very personal experience involving the death of my mother last fall. My mother had always been very clear, even before she developed dementia, and that dementia began to take away her capacity. She was very clear. She did not want measures to keep her alive, lying in a bed, without consciousness, with no quality of life, and especially if she were in great pain. Her dementia was not the immediate cause of her death. So she would not have qualified under this bill because she didn't have a terminal illness. But in her case, after 6 years after the onset of dementia, she no longer had the capacity to make decisions. And so other medical conditions left her in a situation which she had feared, in great pain and unable to care for herself. And those other medical conditions did eventually take her life in conjunction with the decisions we as her children and the medical practitioner made at the time. We feel very fortunate that my mother had been very clear about her wishes, though that didn't really make the decisions we had to make easy. We were confident that we were doing what she had wanted to do. So my own family's experience and those of other families in my constituency are why I believe so strongly that Canadians have the right to make advance directives about their care. The second reason that I'm opposing this bill is the fact that it imposed what it calls a reflection period on those at the end of life. And of course, again, those who had dementia or other similar medical conditions would of course not be able to have a reflection period because they no longer have capacity. But even for those who are competent at that point in their life, I believe that the 10 days, which the committee thankfully reduced it to, is still too long, far too long for those who are living in intolerable pain, and far too long not just for them, but far too long to ask their families and friends to witness that suffering. So if there is to be a reflection period, it needs to be even shorter than those 10 days. My third reason for opposing this bill is the fact that it narrows who's eligible to receive medical assistance in dying to those whose death is, quote, reasonably foreseeable. And I know that others have said that we know what that means and it's specific, and the only way I can understand that we all know what that means is that all our deaths are reasonably foreseeable. But what it means beyond that, I have no idea. It's not a term that's used in medicine. It's not a term that's used in law. And so that very ambiguity raises the specter of excluding people who need medical assistance in dying and who would have been qualified for it under the Carter decision. According to the lead counsel in the Carter case, Kay Carter, a fierce advocate of the right to assisted death for those who are suffering intolerably but from a non-fatal condition, even Kay Carter would probably be excluded from accessing medical assistance in dying under C-14 as it stands. And what this will do is force people into incredibly cruel strategies like starving themselves to death to make their death imminent and to allow them to qualify. And Mr. Speaker, I would hope that this House would not impose those kinds of restrictions on people and make them make those kinds of choices at the end of their life. So would I rather have this bill than no bill? The answer, I guess I'm going to have to decide on. And my decision is going to be that, yes, I'd rather have no bill. I prefer to go with the Carter decision. Now, do I think it would have been better to have a bill? Yes, I do. I'm not opposed to having a bill on this, but it has to respect the Carter decision, and it has to have clear provisions in it, and it needs to have a shorter reflection period than 10 days. But if we don't have the bill, what happens? We don't have a legal vacuum. People are saying that. We have the Carter decision, which will provide guidance. There is a legal framework. And I expect, although I didn't actually look this up, but when the abortion provisions were removed from the criminal code, the House of Commons tried twice to create new law regulating abortions. And I'm sure these same arguments were made at that time, saying practitioners will not want to perform abortions because there's no legal framework. But in fact, we went with the court decision, and we still exist with the court decision on abortion as our legal framework. And we have not had chaos in the medical community on that. Not that in any way I wish to compare abortion to medical assistance in dying, but only on this issue of whether there is a legal framework that will apply on June 6th. The failure to meet the June 6th deadline for this legislation, I think, lies with all of us. It lies with the previous government, it lies with this government, and it lies with us as a House of Commons. We all have to take responsibility for missing that deadline. However, I do have to say, I believe the government could have managed the House time better so that all of us could have participated in the debate and that the debate could have been accomplished in a time to meet the deadline. All they had to do was schedule this bill as a priority in this sitting of the House, which they failed to do. That did not happen. Therefore, I will, when the time comes, stand and vote against this bill at third reading, and in the meantime, I will also vote against it at report stage. Thank you very much, Mr. Speaker.